Hello. Welcome to our YouTube channel. If you are new here, please subscribe. This is another video presentation featuring a question on corporation law asked in the 2016 bar exams. The question was, Royal Links Golf Club obtained a loan from a bank which is secured by a mortgage on a titled lot where holes 1, 2, 3 and 4 are located. The bank informed the board of directors that if the arrearages are not paid within 30 days, it will extrajudicially foreclose the mortgage. The board decided to offer to the members 200 proprietary membership shares, which are Treasury shares, at the price of 175,000 pesos per share even when the current market value is 200,000 pesos. In behalf and for the benefit of the corporation, Peter, a stockholder, filed a derivative suit against the members of the board for breach of trust for selling the shares at 25,000 pesos lower than its market value, and asked for the nullification of the sales and the removal of the board members. Peter claims the club incurred a loss of million. The board presented the defense that in its honest belief any delay in the payment of the arrearages will be prejudicial to the club as the mortgage on its assets will be foreclosed and the sale at a lower price is the best solution to the problem. Decide the suit and explain. The question requires us to pinpoint relevant facts to help us answer the question. 1. The corporation obtained a loan from a bank secured by a mortgage. 2. The mortgage will be foreclosed if loan is not paid. 3. To pay, the board decided to offer Treasury shares at a price lower than the current market value of the shares. 4. A stockholder filed a derivative suit against the members of the board for selling the shares at a price lower than its market value. 5. The board presented the defense of good faith. The defense raised by the board should remind us of the business judgment rule. This rule provides, questions of policy and management are left to the honest decision of the officers and directors of the corporation, and the courts are without authority to substitute their judgment for that of the board of directors unless said judgment had been attended with bad faith. Can this be applied in this case? Will the fact that the Treasury shares were sold at a price lower than its current market value defeat the claim of good faith? To answer, let us discuss the basic principles of Treasury shares. Treasury shares are shares of stock which have been issued and fully paid for, but subsequently reacquired by the issuing corporation by purchase, redemption, donation or through some other lawful means. Such shares may again be disposed of for a reasonable price fixed by the board of directors. Notice that the law provides that the shares may be disposed for a reasonable price, and that price may be fixed by the board of directors. Will the selling the shares below its current market value result to watered stocks? Definitely not, as we are dealing with Treasury shares which have been issued already and not issuance of stocks. Finally, it is useful to be reminded of the requisites of derivative suit. Rule 8, Section 1 of the Interim Rules of Procedure for Intracorporate Controversies provides the 5 requisites for filing derivative suits. 1. He was a stockholder or member at the time the acts or transactions subject of the action occurred and at the time the action was filed. 2. He exerted all reasonable efforts, and alleges the same with particularity in the complaint, to exhaust all remedies available under the Articles of Incorporation, bylaws, laws or rules governing the corporation or partnership to obtain the relief he desires. 3. No appraisal rights are available for the act or acts complained of. 4. The suit is not a nuisance or harassment suit, and 5. The action brought by the stockholder or member must be in the name of the corporation or association. Notice that there was no showing that Peter, The stockholder who filed the derivative suit exerted all reasonable efforts to exhaust all remedies available to him as a stockholder. Appraisal right is also not available for the act complained of. Hence, absent any showing that Arnold endorsed the certificate to Stephen, the suggested answer to the question is, the suit should be dismissed because business judgment rule applies in this case. It was clear based on the facts that the shares sold by the corporate were treasury shares. Under the law, such shares may be disposed of for a reasonable price fixed by the board of directors. Absent any showing that the price fixed was attended with bad faith, the business judgment rule applies. Assuming that Peter can prove bad faith, the derivative suit will still be dismissed for failing to comply with the requirement of exhaustion of administrative remedies, and the right of appraisal is not applicable for the corporate act complained of. We hope you learned something useful in this video. Thank you. If you liked this video, please subscribe to our channel and like our Facebook page ECS Notes. You may also comment and share this video to your friends. Have a pleasant day.